Welcome to today's Litigation Quality PatentCast. I'm Craig Thompson of Thompson Patent Law, and this is the story of the patent fight between ZeroClick, which originated the patent arising out of the UK, and it was written pro se by a doctor who wanted to improve the writing of charts on like an iPad equivalent without using finger gestures rather than clicking like you do point and click with a mouse on a screen. And so you've got this sort of David and Goliath story where ZeroClick has a patent that happens to appear to land on or be infringed by Apple with all the finger gestures that you can do now on the mobile devices, iPhones and iPads, and you're able to control the device with just swiping in different directions and making different movements. You're able to interact with the device. ZeroClick came up with that idea back in the late 1990s. Around 2000, I think they filed their patent application in the UK. And here it is, a US patent. The case that we're going to talk about today was decided June 1st of 2018. And it is an appeal by ZeroClick because their patent claims to this software, this technology for this, I'm going to call it finger gestures for lightly swiping across the screen to get to make things happen with your screen, your computer screen, and interact with an existing program. This is an appeal where in the Northern District of California, the district court ruled in favor of Apple and said this patent is invalid. And the basis for that invalidity, one of the findings at the district court was that this claim fell under means plus function language. And so we're going to talk about how this developed. This 112.6 or means plus function type analysis is what this case is really about, and whether the interplay between 112.6, means plus function, and whether the claims are indefinite, what you can do about it. So I'm going to draw some lessons for how to avoid the problem that happened with ZeroClick. And right off the bat, sort of David and Goliath setup between this doctor in the UK who wrote his own patent application. The patent application, the first one of the four patents, was 90 pages long in the two-column issued patent format. There were 45 sheets of detailed figures and 45 sheets of description and claims. And there was no law firm apparently involved in the U.S. at least. There were 105 claims were issued, and the Federal Circuit boiled it down to just a handful, about a couple of claims that we really focused on. And that just gives you an idea of how much work this guy put into it. And ultimately, I think the result is going to be that ZeroClick's patent is going to go down again in flames. It lost at the district court. It was invalid by the district court. Went up to the Federal Circuit. The Federal Circuit revitalized it, came back to life on this one simple issue. But I think when it goes back down, Apple has plenty of other defenses available to it and other problems with this patent. I think primarily because it was not professionally drafted. Even very smart, super intelligent people, this UK doctor, obviously a brilliant guy. It just shows you how you can get in trouble and create yourself a lot of lost opportunity and a lot of extra litigation expense and loss of time because, trying to save a few bucks, penny wise and pound foolish, the pound being the appropriate currency here for the UK doctor. Basically, although ZeroClick's finger gesture patents were temporarily brought back to life on appeal, I believe Apple has ample avenues to kill it off permanently when it gets remanded back to the trial court in the Northern District of California. I think that's the backyard of Apple. The patent, which was drafted by this doctor who wanted to improve the patient charting process without having to click on a pointer, was not invalid on the ground that it should be interpreted in means plus function form. If it were so interpreted as means plus function, it would be very likely have stayed dead on appeal. But Federal Circuit said it's not 112.6, it's not means plus function. However, like I said, Apple does not appear worried. Apple simply, I think, used this patent as a cat toy, as an opportunity to take a shot on a relatively weak patent to try to undermine a huge swath of all software patents that might have been subject to this means plus function. It's an extra layers of requirements that if you don't meet them, a lot of means plus function claims are invalid because they aren't properly crafted. I think that's what's really going on here. I think it was Judge Toronto at oral argument was asking, isn't that what you're really doing here? Aren't you Apple? Aren't you really aiming to try to take out a lot of software patents that are written maybe by lower budget levels, and maybe would if we can get words like program code and user interface code, if we can get those words to be interpreted as automatically triggering 112.6 like module has been since the Williamson decision. When you see the word module, that's not enough structure. So now, the Williamson decision and others have, basically the law of means plus function now is that if you just say module or thing or device, there's not enough structure there, so it's automatically almost triggers the means plus function language because they're considered nonce words. They don't really have a meaning, or they're nonce words. And Apple's real objective, in my reading of the tea leaves, they were trying to get program code and user interface code considered as nonce words. So I think this was just a trial test case that they said, oh, what the heck, we've got plenty of ways to get out of this patent. Let's see if we can't take a long shot and see if we can, because Apple's arguments were strained, in my view. There was just this one point, and they were trying to, at oral argument, there was a lot of confusion. They seemed to be trying to cloud the issue, or trying to weave it or make a tap dance, however you wanted, around the issue of indefiniteness, muddling and mixing of the issues. So the case isn't really clear as far as any legal precedent. But I think it's really interesting what appears to be Apple's grand strategy to try to come up with a new tool, these nonce words to undermine probably thousands of patents that they might have to otherwise license or have to deal with infringement. So this was a unique opportunity. I thought it was a clever strategy, if that's what they're trying to do. And I think Judge Toronto sniffed it out. So that's where I think he was right on the money there. That's kind of what was really going on in the real news here. Otherwise, there wasn't much really happening in this particular case. But I will note a few things that are practice pointers for litigation quality patent practice. So one of the takeaways is that the Federal Circuit did not go with the idea that Apple was pushing, that the word program or the user interface code automatically makes a claim into means plus function language, or 112.6 language, or now since the AIA 112F, still under the old law before the law changed. So this 112.6 is but it really is no difference. 112.6 and 112F are essentially the same. It's just a renumbering. In this case, ZeroClick had claims directed to the control of a mobile or computer device via this touch movement or swiping without clicking. They argued that the district court erred by construing the claims as means plus function format. The Federal Circuit agreed that that in this case, UI code and program code are not nonce words that require means plus function. And there is a rebuttable presumption, but a presumption that if you don't use the word means, then it's not in a means plus function format. So the fundamental problem here from a litigation level of why the case came out the way it did is that the trial court did not, in its reasoning, address the rebuttable presumption. They just ignored the presumption. They just said, ZeroClick says this, Apple says that, we agree with Apple. They didn't give effect to the rebuttable presumption. So it's no longer a strong rebuttable presumption that the fact that if you don't use the word means, it used to be much harder to try to convince the court because of the strong presumption that if the word means isn't in the claim, it's not a means plus function claim. If the word means is in the claim, then it's strong presumption. It's a means plus function. Now it's no longer a strong presumption, but it's a presumption. And that, because the court ignored that presumption, they didn't address it, that was reversible error, remand back, and the Federal Circuit criticized the district court, saying, don't convert automatically these words like program and user interface code into these nonce words that are effectively the equivalent to saying means. Under the Williamson line of cases, the word module is a type of word that's considered a nonce word. If you see the word module, that the presumption is it is a means plus function in format. So then you have to meet all the means plus function rules and interpret it under means plus function, which is where a lot of claims break down. So it's an extra set of requirements that makes it tougher for the claim to remain valid. Because it's not means plus function, it didn't have to satisfy that extra layer of rules, it reversed the validity, so the patent's alive until Apple kills it again. In this case, one of the interesting things about it is the first thing, before I knew it came out of the UK, what I noticed about it, it had this interesting style of claiming that I've never seen before. And it was based upon, most of the claim was this big preamble about what's the prior art. Okay, this is very different than typical U.S. claiming practice. And I said, well, big long preamble about, optionally could be, an existing type of computer system, but it even said optional in there. It wasn't even required. And so it was very strangely worded. And if they would have involved a U.S. patent counsel with experience in software claiming, we probably would have fixed that and redrafted it to clean that up. And that would have helped, and we wouldn't have needed this litigation, at least on this issue. And then the second half of the claim, after this big long wind up talking about here's what the prior art is, it's an improvement of the prior art in the second half of the claim, where sort of like wherein the improvement comprises. And this is a European style format that the Europeans really like. Here's where the prior art left off, and the improvement comprises, and then it ends with what's the point of novelty, the new improvement aspect, the delta over the prior art, which makes it really easy to see the point of novelty. And in this case, the point of novelty was quite clear, and the Federal Circuit judges, I agree, they all locked in on this new twofold functionality of first detecting a finger location without pressure, and second step is determining from that detected finger location a selected operation. So one of the issues that wasn't exactly argued, but I think will be on remand, it wasn't exactly argued in this appeal, was, well, did they really describe how to make and use that? Did they really enable? Did they really show possession of that? Or is it just sort of a high-level abstract issue, description of what we want it to do? And it could be done in lots of different ways now and in the future. And one of the concerns by Judge Rainha was, well, this is kind of functional going down the road. The Judge Rainha was concerned that even if it's not a means plus function, the functional type of claiming, that language of determining a selected operation, that's a function. And detecting a finger location, that's a function. There's no structure there. There's no apparatus. There's no algorithm really, expressly in there. Maybe implicit algorithm is step one, step two, maybe. It's pretty abstract. So there could be abstract issues under 101. There could be indefinite. There could be possession issues, written description, enablement. There's all sorts of potential issues that I think Apple's got defenses. I don't know if they're too worried about it. Obviously, it's a big deal if they do infringe. So I can see why they wanted to take an extra special shot and deal with this on appeal. But generally, the issues in this case are a bit of a hot mess of a mixture of indefiniteness and whether to treat the claims as means plus function. The unique twist is that Apple pinpointed its fire on this prior art portion of the claim. And again, this preamble was any existing program that can operate movement of the pointer over a screen. Apple unsuccessfully argued that the existing program was indefinite because it wasn't specifically described. However, the judges, I believe properly, took the view that the invention really lies in the improvement to the known system. So it really doesn't matter what the details of the prior art that weren't described. Now, here's my litigation quality patent practice tip on this back and forth between Apple and the panel on the Federal Circuit. Here's what I would say. I would say while taking prior art as granted can be risky, it's certainly it's really not necessary to describe the prior art in great detail in the disclosed specification of figures. I believe that's wasted effort, because if it's already in the prior art, once you sufficiently bring a person of ordinary skill in the art to it who has presumed to have unlimited knowledge of all the skill in the art and unlimited access to everything that's in the prior art within their field, it doesn't require a lot of detail. Now, however, at the point of novelty, the new combination of features, I think the disclosure needs to be far more specific and detailed. And that's where the real value comes in drafting the patent application properly. Is first you have to identify and be able to articulate the point of novelty, and then dive in deep at that point, not dive in deep on all the background prior art. And that's what we see a lot of, is sort of regurgitation or rehashing and pages and columns and columns of prior art description that really had no value whatsoever to the patent asset, to the client. But it does make it look thicker and makes people feel better that they got something for their money. But it really is wasted effort and really indicates a lack of understanding on the patent drafter as to what is the point of novelty, where the value really is, and where the money really should be spent, focused on that. And that's why I wrote about that in my book, Patent Offense, which, by the way, was the #1 bestseller on Amazon. You can get it through our website or on Amazon, called Patent Offense. And in there I explain in detail, as a resource if you'd like, about why the point of novelty makes everything in the patent process less expensive, more valuable, faster, better, cheaper. I believe a litigation quality patent will avoid costly confusion and problems that were experienced by, in this case, ZeroClick, by briefly but clearly teaching how to make all the necessary connections between the new invention and the old prior art. As long as you've described those connections, in this case, it was any existing software program is what the claim said in ZeroClick's patent. There was a lot of back and forth about whether that description of all existing programs that involve a pointer, a mouse pointer, was adequately described. How much detail did they need? The Federal Circuit judges seem to say strongly that why do they need to explain that? That's the prior art. They had this new two-step improvement that was really the focus. And so Federal Circuit judges aren't screaming for a lot of detail about the prior art. They want you to pick up at where the invention starts. And I'd say you should go back and at least address the connections backwards to both the new stuff, the new point of novelty, to the old stuff, and how they connect together. It doesn't have to be long and lengthy, but that's where the most sophisticated value comes from, and the best value from a patent drafting point of view. So, in other words, it's best practice, I believe, to explain how to incorporate the new gesture interface algorithm into the existing computers to control pointers. So I don't know if that was done or not in the patent. I didn't read all 90 pages. The connections back would be how do you actually implement, how do you make and use? Yeah, the requirement for definiteness and possession and written description is to be able to describe how to make and use the once you've described how to make and use the invention by connecting it back to what's existing, that should satisfy everybody and would avoid all this whole challenge over definiteness and means plus function and lack of sufficient structure and all these terms that were being thrown around in the briefs and the oral arguments. So that is a lesson about how litigation quality patent drafting can give you less expensive, avoid litigation, less expensive in terms of prosecution because you'll get through the patent office quicker because there'll be more clarity, more focus, and that's why it pays to do it right the first time. Okay, and unfortunately, after all that work, I don't know if the good doctor over in England is going to get his full due after the full scrutiny goes through it. So, sort of like landing an airplane, I'd rather have a trained professional do it than try to figure it out on my own in midair. So, all right. Well, thank you for your time and attention, and I wish you a profitable day.